answer. Then third one is perhaps the general questions are asked. As far as getting through the objective type is concerned, there is no problem. Why? Because you must use your brains. If you have mortgaged your brain somewhere else, please remember you cannot succeed. As far as the objective type is concerned, the definitions part of it I shall first discuss and then come to the subject in the proper perspective. The first term that is defined in the section 2 is what do you mean by a suit? Suit is a claim initiated by a person called the plaintiff, and the plaintiff is normally in Telugu called the Vadi, and the person against whom the suit is filed is called the defendant, or in your Telugu language is called Prativadi. But as far as the claim which we initiate in a civil court, it is called a suit, or we call it as in Telugu, to put it straight, it is Manu, and in Hindi it is Dava. And the same word is used as far as Telugu is also concerned. Why? Because in Telangana we are half Telugu and half Urdu. And please remember, it's very, very difficult to translate certain words from English into Telugu. Because Telugu is a complex language. But to the best of my ability, I will try to translate it into Telugu because unfortunately, Telugu was my first language in school. Here, I don't think I am a bad speaker in Telugu, but one thing is this, basically I am a Tamilian. But the question is, here and there, Tamil words also come when I talk in Telugu. Here, first term that is defined is plaintiff. Plaintiff means Vadi or Daveda, as we may call it in Hindi. Here, as far as a plaintiff is concerned, he is the person who knocks at the doors of a civil court and files a document, and also with a list of grievances what he has got against the opposite side. Unfortunately, in India, a law is born every day. And please remember, no one can claim mastery over laws, and no one can say, I am a master, I know all the laws. For example, when we people studied, we didn't have the PMLA, the Terrorist Act, so on and so forth, FEMA, FERA, COFEPOSA, and then you got the Monopolies and Trades, now the Competition Commission, and then the Consumer Act also was not there when we studied. But you people are fortunate, you have all these subjects when you are studying law or you come out of the portals of the law college. And as far as my experience goes, I was there for 28 years in the law college. I worked in university as an assistant professor. I was popularly nicknamed as the son-in-law of the university. And I elected well and university. The question is, all those things are bygone. And I had the occasion of even training of IAS, IPS, and revenue officials in the Marie Chenarelli Institute of Human Resources. And I was there for 10 years there, and most of even your police commissioner today was my student there. And I was also associated with the company secretary's chapter for 19 years. I was teaching law subjects, and I'm an auditor examiner for ACS and CIB, that is bank exams. And I also trained law officers and law assistants in railways for 10 years. Now I am with you. The question is, profession has become part-time for me. The question is, I've got illustrious colleagues with me who don't bother me also. They say, sir, please come when the trial is to be taken up. Then this is what is a small introduction. So the first word that is defined is called the plaintiff. Plaintiff is the Vadi who initiates an action in a court of law, especially in the civil court. And the person against whom the suit is filed is called the defendant, who is called upon to defend the claim made by the plaintiff. And please remember, here it's appropriate for me to describe, please remember, the objective type, the question which is often asked is cause of action. What is the meaning of cause of action? Please remember, cause of action means cause of action. That, because I have also valued some papers of your DCG earlier before online. Cause of action is bundle of facts and bundle of documents put together which constitutes a cause for an action in a court of law is called cause of action. Again I repeat, bundle of facts and bundle of law which put together substantiates or establishes the claim of the plaintiff, it is called cause of action. And please remember, you will also be asked the cause of action means and includes dash. That means bundle of facts and documents put together which enables the court to decide a particular matter is what is called cause of action. Then next one is what do you mean by documents? Please remember documents means and includes, I'm sorry, not excludes, includes anything in writing, anything in a lithograph, anything in a caricature, anything in an inscription, anything in the form of a registered document, registered or unregistered, it is called a document. Then next one is what is meant by evidence. Evidence means testimony given by a particular witness in a court of law, either oral or through documents, is called a document. And document is of two types. Most of you know that even now 65D has been introduced after the information technology has come into force, whereby they say even a document in a computer or document taken by a mechanical process is also a document, and electronic documents are also admissible. Then we go to what is called issue, written statement, or what you call it as Jawab Dawa. That is what అంటే మీరు దావాకి మీరు సమాధానం రాస్తారు కదా, అది రిటర్న్ స్టేట్మెంట్ అంటారు. Then written statement is filed under order 8. Then we go to what is set off. I think set off and counterclaim. What do you mean by set off? Set off means where the plaintiff files a particular suit for a sum of money, and you as a defendant say, sir, I have already paid this much, and this amount has to be deducted from the amount that is. Pardon? The amount that is payable to the plaintiff. I want this amount to be adjusted out of the amount payable to the plaintiff. That is what is called set off. Instead of going for a separate suit, in the same suit, when you file the written statement, you can claim the set off. Set off is supposed to be an adjustment of the debt, where the defendant says, sir, out of the money which is due and payable to the plaintiff, I have already paid this much. This amount has to be deducted from out of the claim made by the plaintiff. This is called set off. Then we have got counter claim. What do you mean by counter claim? That is, suppose let us say a suit for eviction is filed under 106 Transfer of Property Act, and the defendant makes a claim counter saying, sir, the plaintiff promised to execute or renew the lease and promised to execute a lease deed for further period of 5 years. Please compel him to execute the lease deed. Instead of going by a separate suit, in the same suit, he can raise that claim and the court can adjudicate upon that matter. This is what is called a counter claim. Then we go to issues. What do you mean by issues? Issues is laid down in order 14 CPC. It means the points of variance between the plaintiff and the defendant. And the plaint and the written statement, if you take it out, what are the points in which they are differing? That is called what are the points that has to be determined by the court. That is called issues. And issues is laid down in order 14 Civil Procedure Code. And non-framing of issues is also fatal. That means AR 2001 Supreme Court, which says what all of the necessary issues that have to be framed, the court has to do it. If it doesn't do it, it fails in its duty. Then we go to Order 18. Most of you are aware of Order 18. Drastic amendments have been brought about by Order 18. That is, and please remember, most of us, some of us are good in writing, some of us are good in only speaking, blah, blah, blah. And oratory anyone can do. But as far as court craft is concerned, only some advocates can specialize in. Please remember, I don't blame any advocate for that, because some of us come from the vernacular also. It is very difficult for us to express ourselves before the court. First and foremost, you must remember is you must remove the stage fear from you. I've seen some advocates like Sravanti Telso represent Jastar. The question is, and one of the tricks is in this profession,
Once you are good in oratory, court will bend before you. But if you are hesitating in representing, then the question is, the court will try to take you left and right. But you need not bother about it now because the courts are almost that ignorant like you. They have to be enlightened, they have to be taught as to what is the basic procedure. Then we go to exam here in CRPC, most of you know, there is a provision called 314 CRPC, which says written arguments can be filed by the parties. But here, they felt in Civil Procedure Code, they also introduced a provision called Article 18 Rule 2, bracket 3. After the evidences are over and the matter is heard, the court grants 7 days time to file the written arguments. And once the written arguments are filed, notice is also given about the written arguments to the opposite side, and the opposite side is also given an opportunity of filing the written arguments. Then the court proceeds for judgment. Then after that, we have got one more amendment, which is Order 18, Rule 4 and 5. There they say all evidences in chief shall be filed by an affidavit. But please remember, most of us are committing a mistake when we don't go to the plate, get the type is affidavit quotation. What that man does is pass of action, it's a court fees, it's a jurisdiction, it's a prayer, it's everything he types. Please remember, evidence affidavit cannot be a substitute. The pleadings cannot be a substitute for filing affidavit. Affidavit should be the sum and substance of the claim. That is how an affidavit has to be filed. Be as short as possible, be as brief as possible, so that you don't get caught anywhere. And all evidences in chief has to be filed in normally the first person. Here you must remember one thing, as far as we Hindus are concerned, Hindus only take oath. Until Pramana Kesi Rasa. As far as the Muslim is concerned, Muslim doesn't take oath. This is the basic thing you must remember. Muslim only affirms to the facts mentioned in the affidavit. He is called an affirmant. And what is stated by him is only an affirmation. And you don't use the word deponent as far as the Muslim is concerned. The word which you use there is affirmant. And you say, don't say sworn and signed before me. There you say affirm and state as sign on this the day of so and so. So this is a basic thing you must remember as far as the Hindu and a Muslim is concerned. And then we have got Order 20. Order 20 which speaks about judgment and decree. Here, most of you know the spelling of judgment. Judgment is spelled in two ways, Judgment and Judgment. Both mean the same and both are synonymous. If you break up the word judgment judge means presiding officer, ment means dicta or pronouncement of the presiding officer in the course of his duties is what is called a judgment. Or tirku or tirmanam or faisala, as you may call it in the vernacular. Then how a judgment has to be written? Writing a judgment is an art. Why? Because everyone cannot master it. Everyone cannot be a specialist as far as writing a judgment is concerned. Some of you are going to be judicial officers. You are going to learn it in the course of your duties. Please remember, the same day when you join office doesn't mean that you can write a beautiful judgment. I could tell you by experience, most of the judges depend on outsourcing also. Because I was also a culprit there. I don't want to give the names of the judicial officers. Anyhow, judgment means pronouncement of a judicial officer vis-a-vis the facts of the case. That is what is called the written statement, facts, and then the case of the plaintiff, case of the defendant, and the evidence that has come on record, and then the cross-examination, which has been elicited by the opposite side, and the inconsistencies and contradictions in the cross-examination, and also the case law on that particular subject, and how far the case law applies as far as the facts are concerned, that has to be discussed by the judge. And then ultimately, the judge has to go on issue by issue, and each issue has to be separately dealt with, and then findings given. and then when the judgment is pronounced, the judge signs on the judgment, and seal of the judge is put, and the day on which the judgment is pronounced is also mentioned. Then what is the time within which a judgment has to be pronounced? Please remember, our judges are so busy, they don't have time to write the judgment. I'm not talking about our lower courts. High court also is the same situation. High court, it takes 1 year or 2 years for a judgment to come. Someday it comes on the list for judgment, you don't notice it, judgment is pronounced by the time Mangala is done. A successful party will execute the decree. The question is, judgment earlier in the old code of 1908, it had to be pronounced immediately or within 14 days. That was what the position was. But slowly they felt courts are always immersed with work. They don't have time. Now, according to the amended CPC, within 30 days, the court can pass a judgment. But please remember, the court also plays a mischief here. What they do is they reopen the case, for they reopen the case for further hearing, or they request the parties to file an application for reopening so that they get a fresh period of 30 days. So like that, it goes 30, ultimately after 8 months the judgment is pronounced. If you see the judgment, Rama's Sita Emota is of course, I don't want to criticize. Then we go to what are the contents of the judgment. First, the contents of the judgment is what is the designation of the court, what is the name of the presiding officer, date of judgment is also good, name and the suit's number in which the judgment is pronounced is also introduced, and then the names of the parties, the plaintiffs and the defendants are also mentioned. Then the heading comes judgment. This suit coming up before me on this the day of so and so, before Srimati Sravati for the plaintiff and so and so for the defendant. This court just passed the following judgment. Then the judgment comes. Then what the judge first does is he endorses or he tries to read facts of the case, plain and written statement. And then after that, he also mentions the issues that have been framed and then goes issue by issue, and then the evidences which are on record and the contradictions and the admissions and the inconsistencies in the evidence is also appreciated by the court, and the court also cites the case law that has been cited by the parties, and the findings will be given on each and every issue. But sometimes what happens is the court drops the issue and gives a common finding. Then the question arises, suppose the plaintiff succeeds. What is the word that is used? The word that is used is the suit of the plaintiff is hereby declared for so and so, together with cost and interest at so and so, from the date of suit till date of decree, and at so and so rate from the date of decree till date of realization. And then the judge signs it and puts his seal and says, given under my hand and seal on this the day of so and so. Then we come to the next part of it, is called decree. Here, please remember one basic important provision you have to mention is what is executed in a civil court is not a judgment. Your client is not interested about the judgment. Your client is interested only about the decree. How he is going to reap the fruits of the litigation which he has initiated in court. Then how is decree defined in Order 20? Please remember, Order 20 does not define decree properly. Every act, decree means so. Sum and substance of the judgment is what is called a decree. That's how your CPC lays down. But to understand the word decree in the proper sense, what happens is you come in the morning, in the evening when you are tired from work, you go to a fruit seller, fruit juice dealer, and ask him to give you a sugarcane juice. What the sugarcane juice dealer does is he crushes the cane, takes out the juice, and then puts a filter, and on the filter he filters the juice, and the residue remains at top, and the filtrate comes down. What you consume is the filtrate and not the residue. That filtrate or the clear solution which you consume is called a decree. Are you able to understand, please? Distillate of the Madakattina Rasam Edaitundo, Adi decree. The residue is thrown out. Residue is not consumed. Residue is thrown out in the dustbin. So So sum and substance of the judgment, the distillate of the judgment, the clear solution which you consume after filtration is what is called a decree. And what is executed in a civil court is not a judgment, but it is a decree. So decree has to be defined in that particular fashion. Please write down this. I think we are giving it on the live also. Distillate, the distillate of the judgment, a clear solution which comes out after filtration is what is called a decree. Then question arises, after all, we are also human beings. There are some arithmetical errors, clerical errors, or some errors which have come in. Then how to correct it? Like a normal child, you cannot correct the marks and fool your father. But here, as far as degree is concerned, there is a provision called 152 Civil Procedure Code, where a degree can be corrected by the civil court, which marks the judgment at any time when the errors or omissions have been highlighted. That is section 152 of the Civil Procedure Code, and 153 says at any time a petition under 152 can be filed. Then the question is, most of the cases, in money suits especially, 1 degree is passed. But in some cases, 2 degrees are passed. One is called a preliminary degree and another is called a final degree. What do you mean by a preliminary degree? Preliminary degree means instances where a suit is filed for partition, suit is filed for accounts, suit is filed for mortgage, suit is filed for some other thing, I mean mean profits in an eviction suit. In all those cases, preliminary degree is passed first. First, even in a money suit, in a market suit also, the court passes a decree. The plaintiff, the defendant, who pays the plaintiff a sum of rupees so-and-so towards the principal, so-and-so towards the interest, and so-and-so towards the cost. And then who should pay whose cost? All these things will be mentioned. And one more important thing is, after the judgment is passed, you are given 7 days time before which you have to file what is called memo of cost. It is called MC and FC. MC means memo of cost, FC means fee certificate. Memo of cost means what is the stamp duty you have paid, what is the court fee you have paid on the plea, what is the process you have spent, how much you have paid for the witnesses, how much you have paid for commissions, how much you have paid to the advocate, how much you have paid to the junior advocate, and the miscellaneous. That is as far as the cost of the plaintiff is concerned. Same thing applies as far as the defendant is concerned. And suppose you have to recover cost, please bear one thing in mind, that unless the fee certificate is filed by the advocate, your fees will not be included there. Most of us don't file the fee certificate. The reason is you have to explain the income tax bill. And even the fees which you certify will be the fees that is available to under the Advocate Fees Act. And please remember, no one goes by the Advocate Fees Act, at least me. And you have also to guard yourself against the parties today. I think most of you know that the parties will give you the expenses, but as far as advocate fees is concerned, the bank में है, आपके पास है तो क्या, मेरे पास है क्या, तो बैंक में है, बैंक में रख के मैं क्या करने का है? The question is, fee certificate is normally not certified by the advocate. Then the question arises, suppose you want the fees to be included, you can file an application by inadvertence, fee certificate was not filed and file the fee certificate now. So, preliminary degree is passed in all these matters. Suppose you take the partition suit. In the partition suit, you claim 1/4 share in the property. Then the court says the plaintiff is entitled for 1/4 share in the Schedule E or Schedule B or whatever it is. B is a preliminary degree is also passed for partition. That is not the end of it. What you have to do is you must file an application before the court under order. Yes? Under order 26, order 26 to 13 to get a commissioner appointed, and the commissioner will go to the spot. He will take the assistance of the revenue officials, measure the property, locate the property, fix the boundary stone, and says, "Sir, I've already divided the property." Then, as far as allotment of shares are concerned, the court has to allot the shares. The commissioner has no power to allot shares. Please bear that in mind. Some of you are commissioners who are appointed for the purpose of division of property. Your job ends by dividing the property, that's all.
But as far as shares are concerned, it is a duty of the court to allot the shares. Then what happens is, once a preliminary decree is passed, then you file an application for passing a final decree and another application for appointment of advocate commissioner to divide the property. First, what happens is the court decides the commissioner application first, and then after the commissioner files the report, objections are also filed, objections are heard, and the court passes the final decree. But one thing you must bear it in mind, at the time when you file the suit, you only paid a fixed court fee of 400 rupees, let us say. But once your share is determined, the value of your share in terms of money, you will have to deposit court fee. And then what the court does is, it engrosses the decree on a stamp paper and then gives it to you. And under section 18 of the Registration Act, the registration of a final decree is only optional. You can go to the sub-registrar based on the decree and get it registered. And what is the advantage of getting it registered is, it becomes a title document as far as you are concerned. Then you take the case of a mortgage suit. If you take the case of a mortgage suit, first the court says the defendant paid to the Mike? As far as the mortgage suit is concerned, can you tell me under what provision mortgage suits are filed? It is not order 7 to 1 and 2 read with section 26 CPC. A mortgage suit is filed under order 34 civil procedure code. All mortgage suits are filed under the provisions of order 34. And as when you file a mortgage suit, don't try to mention the word order 741. Order 741 does not apply as far as mortgage suits are concerned. And even your section 26 also does not apply as far as the mortgage suit is concerned. What is the provision to file a mortgage suit is order 34. Order 34, most of the people who are appealing for banks and financial institutions are aware of it. Well, what are the particulars you have to mention? The same thing like a money suit, but a paragraph has to be devoted for mentioning the particulars of the mortgage. That is, name of the mortgager, name of the mortgagee, amount sanctioned, interest charged, amount paid, and then next one is the date of the loan, and then after that you mention the description of the property that has been given as security, and then you say what is the total amount receivable. Then in the prayer clause especially, you have to mention the prayer very, very carefully. In the prayer clause you say, the plaintiff therefore pays for a judgment and decree against the defendants jointly and severally. Why I am saying jointly and severally is, sometimes characters also are there. Then in that case you ask for an individual and a joint decree for payment of rupees also towards the suit claim with interest and so on. Then B, you say for a preliminary decree in default of payment, for a preliminary decree for enforcement of the charge by way of foreclosure or sale of the property belonging to the defendants. Then please remember, one basic thing you must remember is, an installment decree cannot be passed in a mortgage suit. This you have to kindly note, please. Order 19 and order 20 does not apply to mortgage suits. What is granted is equity of redemption. Equity of redemption means the defendant will be given a right of paying the principal, paying the interest, paying the cost either directly to the decree holder or depositing that amount into court. And then one more important thing you must remember is, be it a mortgage suit or any other suit, the schedule has to be clearly mentioned. In the schedule.
So, as far as mortgage suit is concerned, schedule has to be mentioned. Just like you describe yourself as Srimati so-and-so, wife of so-and-so, age so-and-so, the plaintiff above name declare that the facts stated above is true and correct. But in the schedule you say the boundaries and the description of the property given is true and correct. And then you verify the schedule and then sign. So please remember, schedule has to be correctly mentioned with the Sariyandulu or the boundaries. So schedule plays a very important part as far as a mortgage suit is concerned or suits relating to immovable property. That's the reason initially in a mortgage suit, a first decree is passed to directing the defendant to pay the suit amount. And then after that in default, a decree is passed. Default they say whatever property is offered as security can be proceeded against either by foreclosure or sale of the property in enforcement of the charge. Then you can ask me one question, sir, what do you mean by foreclosure? The word for itself means before. Closure means close. That is before the mortgagor exercises his right of getting back the property by way of redemption, the mortgagee wants all those rights to be extinguished and eliminated. That is what is called foreclosure. Then sale. What do you mean by sale? Sale means where you want the mortgage property to be sold in enforcement of the charge. Here, as far as what do you mean by equity of redemption? Equity of redemption is, I just give an example of the Narsimha Avatara, when Hiranyakashipu was vanquished by Lord Narsimha. That is, before vanquishing or killing Hiranyakashipu, Narsimha took him to the Gattu, that is near the door, and then tried to pierce the chest of Hiranyakashipu and tasted the blood of Hiranyakashipu until the last drop. When he found that no bhakti was left, then he killed him. In the same way, as far as civil courts are concerned, they don't want to knock away or snatch away the property of an individual. Till the last minute, they give you time. Equity of redemption is given to you. At least you have not paid till now. At least pay it now. 3 months' time or 6 months' time is granted, whereby you have to pay the principal, interest, and cost of the suit to the degree holder. Then please remember, it's easier said than done. We advocates don't allow a matter to end with the lower court. We go in appeal, then we go to the High Court, then we go to the Supreme Court, ultimately we come back to the same court. But please remember, Vishamlaga Perutunanmata interest. The question is your client has to pay because Izzat ka sawal. No one wants to live anywhere. But please remember, I can give you some hints when you fight a bank. Because I was appearing for the bank, I know the positives as well as the negatives. Here, the negative part of it is, bank is supposed to maintain a register called the EM register or what is called the charges register. Whatever property is offered as security, the synopsis of that property has to be entered in that book. And no bank maintains this register properly. We as advocates appearing for the bank advise the bank at least fill it up now. Then we fill it up then. And only when the suit is filed, before the suit is filed, the document is prepared. The EM register is maintained. And suppose you are appearing for the defendant against a bank, please remember, most of us have an impression, sir, suit elaborate decree out. Don't be desperate. Don't be disappointed. You call for the EM register. In the EM register, there is no entry made. So a charge is not properly registered. Then sometimes when a charge is created by a body corporate or what is called a company, it is to be reported to the ROC, Register of Companies, and the charge also has to be mentioned in the register of the ROC. Sometimes the company does not do it. Once the charge is not registered before the ROC or the Register of Companies, please remember it is no charge at all. These are all the various defenses. I should not disclose it because tomorrow when you appear against me, you will use it the same thing against me also. So the question is, these are all the basic defenses that are available to you. So we are on preliminary degree and final degree. Once there is a direction to pay the amount, and on failure, there is a decree for foreclosure or decree for sale, and the scheduled property will be sold by auction, and the sale proceeds will be deposited towards the credit of the suit. And here there are two steps. One, you must ask for passing a final degree, and another petition for appointment of commissioner to go and sell the property, and the court itself sells the property. There are various methods through which the property is sold. Then we go to what is called cross-examination of the deponent. Can you tell me what is the provision which gives you the right to cross-examine the deponent? Order 19, Rule 2. When the deponent swears to a false affidavit or swears to facts which are not really true, then in that case you are given an opportunity of cross-examining the deponent, be it a commissioner or be it a witness. You can always cross-examine by filing a petition under Order 19, Rule 2 CPC. Then we go to what is called incidental proceedings. Can you say, some of you are appearing on the criminal side, suppose the accused dies, what happens to the crime? Crime also dies along with the accused. In-laws cannot be made responsible for it. But as far as civil matters concerned, please remember the Muru Katana. That is, suppose you tie the nuptial knot to a bride, whether you like it or not, throughout your life, so the question is, the civil matter does not end. We advocates don't allow a civil matter to end because our subsistence depends upon the longevity of the litigation. Here, Order 22, Rule 3 and Rule 4 are the important provisions you have to mention. You have to remember, that is Order 22, Rule 3 says, when the plaintiff dies, he has got his legal representatives, that is widow and children. They can come on record as the co-plaintiffs and file the litigation or continue the litigation which has been initiated by the plaintiff. That is what is called bringing the legal representatives of the plaintiff on record. That is Order 22, Rule 3. Then we have got Order 22, Rule 4, where it says if one of the defendant dies, the loss of the deceased can be brought on record and substituted in the place of the dead person. That is Order 22, Rule 4. Then you have got the provision called Order 22, Rule 4A. It is the duty of the advocate who appears either for the plaintiff or the defendant to file the death certificate or report to the court, sir, this person has expired on so date. Please give me time to bring the loss on record. Then sometimes it so happens, it is the duty of the advocate to furnish the names of the loss along with the addresses and relationship, but no advocate does it. So in that case, you can file an application under Order 22, Rule 4A to direct the opposite side to furnish the names of the loss and the relationship and the address. Then we go to tell within what period this application has to be filed. This application has to be filed within a period of 90 days, 90. Then you have got a provision called Order 22, Rule 9. Suppose you don't bring the loss of record, if the suit abates, then suit suffers a natural death, legal death rather, I put it that way. You cannot continue a litigation against a dead person or on behalf of a dead person. There must be someone who should represent the estate of the deceased. So, if you don't bring the loss of record, the suit dies a natural death. Then in that particular case, you have to file an application under Order 22, Rule 9, which speaks about setting aside abatement. Setting aside abatement. That is, the period that is given to you is 60 days. 90 days for bringing a loss on record, 60 days for setting aside abatement. And then, even if that 60 days expires or 150 days expires, then you have got our Zinda Tigisman, that is Section 5 of the Limitation Act. When you file Section 5 Limitation Act, continuation of delay in filing the applications. But here, when you file that Section 5 petition, you will have to explain each days of delay or show sufficient cause why the application was not paid on time. And in proper cases, the court confirms the delay. The formula that is followed by our High Court is 1 rupee per day. Suppose 1500 days delay is there, 1500 rupees cost is imposed. Even if you oppose an application, courts are very, very liberal as far as allowing delay petitions are concerned. But please remember, we would be happy if the money goes to an advocate, opposite advocate. No, it is deposited into the DLSA, Legal Service Authority, for having chai pani, etc. But this is the procedure that has to be followed in bringing LRs on record. That is what is called incidental proceedings. Then we proceed to order 23. That is withdrawal and withdrawal. Withdrawal. I think my voice is quite loud. I don't require the mic on. Withdrawal, compromise, and adjustment of claims. Withdrawal, adjustment, and compromise of claims. That is what Order 23 speaks about. Sometimes what happens is you want to file a comprehensive suit, and you have filed a suit, subsequent events have occurred where it gives rise to a different cause of action. Then your duty is to file a petition under Order 23, Rule 1, CPC, ask the permission of the court to withdraw the suit with liberty to file a fresh suit in respect of the fresh cause of action. Then the court grants you leave to withdraw the suit and then file a fresh suit in respect of the fresh cause of action or additional subsequent facts which has come to your notice. That is Order 23, Rule 1. And then the question arises, sir. You may ask a question, sir. What about limitation? Please remember, whatever limitation has occurred at the time when you filed the earlier suit comes handy for filing the subsequent suit once permission is granted. So under Order 23, it is mandatory. You must file a petition, take the leave of the court to withdraw the suit with the liberty of filing a fresh suit. And question of limitation doesn't arise. Whatever limitation was there at the time when you instituted the suit applies as far as the subsequent suit is also concerned. Then we go to adjustment of claims. What do you mean by adjustment of claims? That means, in Hindi they say, Miya Bibi Kazi hai, Razi hai, to kya karega Kazi? Then suppose the plaintiff and defendant come to an arrangement whereby they adjust their claims, amount is reduced, I think your Lok Adalat, etc. And then the claim is decreed. Then in that case, adjustment is also recorded by the court. Then compromise. What do you mean by compromise? Compromise is what is called in Hindi as Sula. What is settled between the parties, where the party has agreed to certain terms and conditions, it is reduced to writing in the form of a joint memo filed into the court, and the court records the compromise and passes a decree according to the joint memo that has been filed. Am I making myself clear to you, please? Then after that, you have got, I think, Order 24, you can omit. Order 25, you can omit. Then we go to Order 26. Order 26 is supposed to be supplemental proceedings. Here, please remember, there is a provision provided for appointment of commissioners. Commissions. Order 26 deals with commissions. Commissions are appointed in different instances. One is, suppose the witness is unable to come to court because of physical and mental disability, then you can ask for an advocate commissioner to be appointed to examine the witness at the place where he is residing. And sometimes people are appearing in the motor accident cases, it is impossible to get a doctor to the court or a surgeon to the court. You ask for a commissioner to be appointed to cross-examine the witness at the place where he is working after taking appointment from him. Under various instances, a commissioner can be appointed to examine a witness. That is the first one. Second one is, a commissioner can be appointed to make a local inspection under Order 26, Rule 9, which says to inspect the property and then note down the physical features and then report to the court. That is Order 26, Rule 9 for local inspection. Then a commissioner can be appointed even to take out inventory. Inventory means what are the stocks found, what are the registers found, what are the various materials found, and what are the things found at the spot. That is what is called inventory. Then a commissioner can be appointed even for the purpose of taking accounts. In a partnership suit, if one of the partner obtains a decree for accounts, then a commissioner is appointed to go to the firm's address and then take out the account books and then find out what is the profits receivable by the particular person who has filed the suit. That is what is called a commissioner appointed for taking accounts. Then next one is a commissioner can be appointed in a partition suit to divide the properties also. That is the next instance. Next one is in a mortgage suit, a commissioner can be appointed for the purpose of selling the property which has been offered as security. Like this, various types. In a suit for eviction, suppose mean profits are granted. Then in that case, a commissioner can be appointed to find out what is the probable amount which the property can fetch if it is let out. That is towards damages and compensation, and that is called mean profit. MESNE. S is silent. So in various instances, a commissioner can be appointed under the provisions of Order 26. You want me to continue or we'll continue tomorrow? I'll come to that. Pardon? I'll come to Order 34. I'll explain. Then the other things 27, 28, 29, 30 and 31. I will explain first Order 32 first. Order 32 speaks about suits by minors, unsound persons, and otherwise disqualified from filing a suit. Order 32 says, I think most of you are aware of the Contracts Act, Section 6 and Section 11 says, a minor, unsound mind, and a person who is an idiot, or a person who is disqualified from entering into a contract cannot file a suit, cannot enter into a contract. In the same way, in a civil suit, a minor cannot directly file a suit, or a suit cannot be directly filed against a minor, because a minor is supposed to be incompetent to enter into a contract. Then what is the procedure to be followed? Whenever a suit is filed by the minor, then a minor has to be properly represented by his guardian. Guardian means a person who is in custody of the minor. It may be the father, it may be the mother, so on and so forth. It depends on the personal laws of the parties. Or the next friend if the party does not have father and mother or natural guardians. Then in the case of the minor not having anyone, is an orphan. Then in that case, the court appoints an advocate as a court guardian to take care of the litigation for and on behalf of the minor. It is the same as far as the defendant is concerned, as far as the plaintiff. But one basic thing you must remember is a minor cannot file a suit by himself. A minor has to be represented by his guardian. Unless you get him represented by a guardian, your suit is not maintainable. Then in the case of unsound mind, no parent will take the trouble. It is normally filed by the next friend, that is nearest relative, files the suit for and on behalf of the person of unsound mind. Then we go to an idiot. Idiot in Telugu is an eddod. That is, he is not able to discriminate between what is true and what is false. He is not able to know whether this is a bottle or whether it's water. Then in that particular case, also a next friend can file a suit on behalf of the idiot and not otherwise. The idiot cannot file it by himself. Or a person is disqualified by any law for the time being in court. Then in that case, if you take an insolvent or a bankrupt, then in that case, the receiver who is appointed or the liquidator who is appointed can bring an action for and on behalf of the person who is disqualified. So this is how a suit is filed by the plaintiff or against the plaintiff. Then we come to Order 33. Order 33 is supposed to be pauper suits. That is, suits filed in forma pauperis. That means all of us are not fortunate enough to have good finances. Then in that particular case, though you do not have sufficient funds to meet the obligation towards payment of court fee, or you have no funds at all. Let us put it two ways. Then in that case, you can file a suit before the court. Sir, I do not have the money, I do not have sufficient means. Please permit me to file the suit without payment of court fee. Then what happens is the proceeding is numbered as OP, original petition. Then pauperism inquiry goes on. Notice is given to the opposite side. The government is also given notice to file counter. They oppose the application. Suppose, let us say, on evidence which is on record, the court comes to the conclusion that this man does not have the means at all. Then it permits him to file the suit as a pauper. That is in forma pauperis, as a pauper. But don't mistake me by saying, sir, you need not pay court fee at all. Ultimately, when the suit is decreed with cost, let us say, the government has got the first charge over that amount which is payable to the court. That is Devudu Varam Ichina Puja Yaddochana. Government says, Meer Panchaputa Nakevaru. So that is the court. The government can come in and recover that money by way of arrears of land revenue. Then suppose, let us say, after the pauperism is allowed, the person acquires some property somewhere. Please remember, the defendant number one, who is a contesting party, will be just viewing like a hawk where this man is got assets. Then he files a petition before the court to dispauper the pauper who has been adjudged as a pauper. Then in that case, if the court comes to the conclusion that he has got the means to pay the court fee, then directs the party to pay the court fee, and then alone entertain the suit. Once the pauperism is allowed, OP is converted into an OS, original suit on the original side. Then a regular inquiry takes place and the regular procedure is followed. Then we go to mortgage suits, that is Order 34. Order 34, Order 34 speaks about mortgage suits. All suits under mortgage are filed under Order 34. Then what do you exactly mean by the word mortgage? Mortgage is defined in Section 58 of the Transfer of Property Act as an interest in respect of specific immovable property for the purpose of securing a loan which is paid, promised, or part paid or part promised. That is called a mortgage. And the person who offers the property as security is called the mortgagor, and the person to whom it is offered as security is called the mortgagee. And if any person secures the debt by depositing the title, it is called the surety or is called the guarantor. So a mortgage can arise only regarding claim for money, not for anything else. Please bear that in mind. Then, how a mortgage suit has to be drafted? A mortgage suit is drafted normally under the provisions of Order 34. The only difference between an ordinary money suit and mortgage suit is money suit is filed under Order 7, Rule 1 and 2, read by Section 26. But as far as a mortgage suit is concerned, it is filed under Order 34, Rule 1 and 2 CPC. And only difference between a money suit and a mortgage suit is there you will have to mention a paragraph, name of the mortgagor, name of the mortgagee, amount sanctioned, date of loan, interest charged, amount paid, then description of the property that has been offered as security, you have to clearly mention. And last part of it, prayer, cause of action, you have to be very, very careful. In cause of action, you say that the cause of action for the suit arose on so-and-so date when the loan was sanctioned and primarily secured by pledge of immovable property and collaterally secured by mortgage to deposit of title deeds belonging to defendant number 2 and so on and so forth. That is cause of action on whatever date it is. Then the prayer clause you say for payment of for a judgment and decree against the plaintiffs against the defendants jointly and severally for A, payment of rupees so and so. B, on failure to pay the money for a charge or for a mortgage for a decree for foreclosure and sale of the property under the provisions of Order 34. And one thing you must remember is the mortgagee gets the right of proceeding against you personally as far as the property also, both of them you can proceed. But equity of redemption is granted, whereby you are given time to make the payment within a particular time, 3 months or 6 months or 8 months or 9 months as the case may be. And please bear one thing in mind, no installment decree can be passed in a mortgage suit. And then after that, you give the list of documents, whatever documents are filed, and then we come to the schedule of property, give the extent of the land and also the boundaries, and the party signs the schedule and so on and so forth. This is the mortgage suit is filed. The question that was asked was regarding summary suits, that is Order 37. As far as Order 37 is concerned, they are concisely called summary suits. As far as summary suits were concerned, earlier before the Amending Act of 1976, that is Act 46 of 1976 of CPC, summary suits was not applicable to the provincial towns. It was applicable only to the presidency towns, that is Madras, Kolkata and Bombay. But 1976, they amended the Civil Procedure Code and said what was applicable to the presidency towns is also applicable to the provincial towns. That's how it became, right from 76, summary suits became enforceable in our state or other states also. What is the essence of a summary suit? In Telugu, there is a saying, Oche Kotte Teche. That means come finished off immediately and get it disposed of. Elaborate trial need not be done as far as a summary suit is concerned. In criminal law also, you've got summary cases. Summary cases is triable by a magistrate and the maximum period of imprisonment is 2 years and fine of 5,000. That's what is your CRPC, what it says. Here also it says within 6 months a matter has to be disposed of. It applies only in two cases. One is suits based on negotiable instruments. That is suits based on promissory note, suit based on check, suit based on bill of exchange. Or second one is non-contentious matters, for example, arrears of rent, which is due and payable by the defendant to the plaintiff, or your chit fund transactions. In chit fund transactions also, where the chit is there, price chit is there, you are the bidder, amount has been paid to you, it has been secured, so on and so forth. Elaborate trial is not required. And the chit agreement is also registered and you have been given the chit amount. So here you need not go for an elaborate trial. Straight away it can be disposed of within 6 months period. But please remember the procedure is quite rigorous here. When you file a suit of a summary nature under Order 37, it's your duty to send the summons to the opposite side by registered post. And then when you send the summons to the opposite side, you must watch the, find out from the section whether the summons have been served or not. And please remember, when the summons are served, when the defendant receives the summons, he engages an advocate and then files his memo into the court. I have entered appearance. Then intimates the counsel for the plaintiff that I have entered appearance. Please serve all the papers on me. Then within 10 days, he must serve what is called summons for judgment to the opposite side. That is the defendant. Then once summons for judgment is served on the defendant, it is the duty of the defendant within 10 days, he must file what is called his permission to defend the suit. And it should be filed within 10 days period. If he does not file the leave to defend, he cannot defend the suit at all. So, as far as summary suit is concerned, your right of defense is not available to you as a matter of right. It's only a discretion of the court. Then, once leave is granted, court will impose conditions also. What they will say is, please deposit the cost of the suit or deposit 50% of the amount that is due and payable by you. Then alone leave is granted. Suppose leave is refused by the court, then what is your remedy, sir? You can always go by way of an appeal to the superior court and question the order of the lower court. Suppose leave is not granted, leave is granted, then the opposite side, the plaintiff also can file an appeal before the superior court. This is what Order 37 speaks about. I'll go step by step. Once a suit is filed in a summary nature, it is numbered, then summons are issued to the opposite side, and the opposite side makes appearance, and advocate for the opposite side appearance, please serve all the papers on me. Then within 10 days, you are supposed to file what is called summons for judgment, and only when there's a triable case, a valuable defense for the defendant, he can defend it as a matter of right. But the defendant has to spell out his defense and say, this is my defense that is available, sir. Please permit me to defend. Then suppose the court grants leave, then in that case, what the court does is, it passes a conditional order, deposit 50% of the amount or furnish security for the suit claim, and then leave is granted, then it becomes an ordinary suit. The other side will be given an opportunity of filing a written statement and defending the suit. But preferably, a summary suit has to be disposed of within a period of 6 months. We advocates don't allow it to remain, allow to get it disposed of within 6 months. If we allow it, we are not advocates at all. That is, I'm saying for your good only. Because the question is, so long as the client remains with you, you are benefited. So long as the client goes out of you, you don't get anything. So best is fight it out to the best of your ability. Please remember, if you fight it out, you clearly look into it, or if the suit is based on a negotiable instrument, you see. That is what is called promissory. Just take the case of a promissory note, or take the case of a check. If you just deeply go into that matter, you will get the defenses open to you. You can just see whether any material alterations are there, whether the date has been tampered, whether the name is correctly mentioned, whether the figure is correctly mentioned. Is a 50,000, one more zero is added, 5 lakhs is added, or in the receipt there is some amount, and in the promissory note there is some other amount, or let us say in the return state, or let us say in the plate itself, the date of the check is 5/2/2024, but it's a 5/2 in the plate to write it as 5/2/2000 some other day. Where there's a difference, there's an omission, there are acts of omission and commission there. Try to take advantage of it. Please remember, it's very, very easy to find out the fault. See, suppose you write in the ballpoint, most of you can observe also. There are people who write it in different way. M, you take the word M. M people write it as capital M, let us say. There are people who are used to put a circle on this M here and then put that word, put that alphabet M. And when you want to achieve perfection, somewhere you stop. And ballpoint, please remember, just to keep it for 1 second, you get that smudging there. That means the document is smudged and the document is forged. And please remember, the document is, the signature is copied. Then you have to, then you have to study CRPC also. There, 460, I think if I'm correct, it's 468. There are two systems of forgery. One is called tracing method, and another is called freelance method. Tracing method is you put the tracing paper on that and then copy the signature. Very, very easy. But freelance method means, suppose this madam is here. I observe her by writing, how she writes, how she holds the pen, what are the strokes which come out of her pen, and whether it's small letters or big letters. Then I try to copy her signature, copy her handwriting, and try till you succeed. You become perfect as far as copying a signature is concerned or copying a handwriting is concerned. That is what is called freelance method. I can give you my own example that there was a gentleman named Subbarao, the rent controller's court. He had the habit of writing like this. His thumb used to be up and he used to write like that. I also became habituated. I used to copy, and unfortunately, my father was abusing me. So the question is, please remember, if you are very, very careful, if you follow it very, very carefully, you get a point. So please remember, don't be desperate, because one thing you must remember is, here various defenses are available to you. For example, you've got your what is called your NI Act. NI Act, most of the people are scared for defending it. You've got, because one provision is there which is against you. What is that provision? Can you tell me? Golden rules of presumption, golden rules of cross-examination. That is 118 NI Act. Presumption as to the drawer, presumption as to the drawee, presumption as to the date, presumption as to execution, presumption as to consideration, and the presumption as to the person holding that document is a holder in due course. These are the 6 golden presumptions under 118. And what are the defenses open to you in an NI Act, sir? No, NI Act. Then you go to 142. 138 does not apply unless 142 is satisfied. What do you mean by that, sir? That means there must be a pre-existing monetary liability or pecuniary liability, and towards honoring the pecuniary liability, a check must have been given, and the check which has been given is within time, and the presentment is within time, the notice that has been given is within time, and the period for which you have waited for reply is within time, and the period within which you file the claim is also within time. These are all the various defenses that are open to you under 142 of the NI Act. Please remember, where are you? You have to use your brains and find out what are the differences. That is, you say an advocate is normally different. Don't mistake me as Pauper by Ravi. That is, ekkada paapam cheyalani manaku baga telusu annamata. And that's why Abraham Lincoln says an advocate is fond of hair splitting and pedantry. What do you mean by hair splitting and pedantry means an advocate plucks out the hair of the opposite side in cross-examination, hair by hair. And you destroy the case of the adversary point by point. Then when you are asked, sir, where is your nose? As an ordinary person says, my nose is here. But an advocate does not show that his nose is here. He come like this and say, my nose is here. Don't think that the nose is going to become eyes, or it's going to become ears, or it's going to become the mouth, or it's going to become the throat. Nose will remain in the same place. But advocate, why I am trying to tell you that is, there was a judge who became a judge of the Andhra Pradesh, composite Andhra Pradesh High Court, as well as the Punjab High Court. He used to have 3 questions he used to frame at the Vikram Betal. Like, he will frame those questions and then ask the advocate, sir, please answer this question. An advocate who is a clever advocate should not answer that question. If you answer it, you are finished. What you do is go and go round and round and round and round you go. By the time he forgets the question and you forget the answer. So that's why it is said, if you cannot convince, confuse. So these are all the basic tricks of the profession, man. Order 37, again repeating it. Order 37 is a summary suit. Previously it was applicable only to presidency towns. by the amendment of 1976, it was made applicable to the provincial towns also. The procedure that is followed is the suit is filed of a summary nature and OS, and when you file it as an OS, it is your duty to send the summons to the opposite side, and the opposite side within 10 days he has to enter appearance, inform the other side, sir, I've already entered appearance, please serve all the papers on me. Then the plaintiff has to serve what is called summons for judgment to the opposite side, and within 10 days, the opposite side has to file a petition for leave to defend, and then with a triable defense, and the court, if it wants to grant leave on condition, deposit 50% of the cost of the suit, grants leave. It is not a blanket order that is given. But one more important thing you must remember is, suppose the leave is not granted, court need not wait for the trial. Court can automatically pass the judgment based on the pleadings that have been filed before the court. That is the nature of a summary suit. And if you want to hear it in detail, I have already beamed it on YouTube. It is available on Dharma Legal. I think that was the lecture we gave yesterday or day before. And then after that, then ex parte decree can be passed. You can straight away file a petition under Order 37 rule. Then you can ask the suit to file it, pass a judgment on admissions. You have petition. Then file a petition for again with delay condemnation and all. You got this? You can file. I think with this we should stop, because I don't want to go very, very fast also. Please remember, tomorrow we have a change of timing because most of the advocates have to attend the call work also. So we will change that. 11:30, 12 o'clock. 12 o'clock. Pardon? 12 o'clock, yes. Yeah.
We'll upload it in Dharma Legal and you can watch anytime.
అమ్మా నేను పెద్ద మనిషిని కాదమ్మా మీలా నేను కూడా